Let me begin by repeating what Mr. Geithner has said and others. Mr. Liddy is in no way responsible for these bonuses having been agreed to. He, as a public service, agreed to come in and inherited a situation. I disagree with some of the ways in which he's handled it, but there ought to be a clear distinction between people who had a responsibility for creating the situation and those given the responsibility for handling it who may differ with us. And frankly, on some of those signs talking about jail, with regard to Mr. Liddy, they were entirely inappropriate and not, it seems to me, seemly for people who believe in civil liberties and fairness to incorrectly suggest that there was any criminality on the part of this witness. Now, having said that, I do want to say also I have said several times I think the time has come to make some changes. And indeed, I think the time has come for the federal government to assert greater ownership rights. That's in part motivated by what I would think was a stronger legal position if we sued against these bonuses as the owner, charging that there had not been adequate performance to justify the bonuses, as opposed to as a regulator. I think many, myself included, would have more comfort with the federal government as a party in interest, as the actual owner, saying we are exercising ownership rights not to have paid out bonuses when there was a poor performance, than for the federal government to interfere with an existing third-party contract. I also have said that I thought there should be some people removed, and I was not talking about Mr. Liddy, and I may not have been as clear about that. I am very critical of the people who put these contracts in place. As I read earlier from the contract, there is a pool of money to be distributed, and then it says, but losses are to be subtracted from that, but the losses that can be subtracted toward a cap by $65 million. Let me just ask you, Mr. Liddy, is it possible, under the way these contracts were written, that you inherited, that the company as a whole could have lost money, but there still would have been a bonus pool to distribute to the employees?
Congressman, I think the contracts here that you are reading from have to do with performance bonuses. No performance bonuses at FP, zero. It's a different issue than the retention bonuses, where we basically said to people, you have a job, that job's going to go away after you wind down the book of business that you manage. If you'll stay...
You're telling me the only bonuses that were paid recently were the retention bonuses?
Yes.
There were no other bonuses paid?
Not at AIG FP, no, I don't believe so.
Right. And the retention bonuses, some people were told who got retention bonuses have since left, is that correct?
The arrangement, yes, sir.
Did they give back their retention bonuses?
No, the arrangement is if you stay, wind down your particular business, do a good job of it, and we're comfortable with the job you've done, you'll get that retention bonus.
So that some of these are people who got a retention bonus and then they left. What would be the average period of time after which people got a retention bonus if they left? You don't expect to know that off the top of your head. I'd ask you to submit it to us. One other issue before I get to, well, two others. You are optimistic in here about paying down the Federal Reserve debt. You don't mention the debt to the Treasury. Is that next after the Federal Reserve debt?
Yes. It's really important for us sort of pay the debt down first so the rating agencies remain relaxed.
As opposed to the TARP, which is considered a different category? Is that the
yes. Although, could I clarify? I think there's some confusion. Right now, the federal government has invested two major tranches of money in us. One is $40 billion of TARP, and the other is just under $38 billion of a loan from the Federal Reserve. That's it. It's $78 billion. There's another $30 billion of TARP, which is available to us if we have to draw it.
Which are you thinking, and you're talking about paying off the Federal Reserve debt, the $38 billion?
The order in which we would do things is first the Federal Reserve debt, and then the TARP dollars.
Next question before I ask you my final one. Well, I'm running out of time. I would be interested in your submitting in writing, given your experience, whether we should be dealing with this question of an orderly resolution procedure. You were put in place where there wasn't any. The Secretary of the Treasury previously and currently have said we need an orderly way to wind down a troubled non-bank. But let me ask you this now, and you've said some people are giving the bonuses back. I'm now asking you to send us the names of those who received bonuses who have not given them back. Can you do that?
Sir, I will if I can be absolutely assured that they will remain confidential.
Well, I won't give you that assurance, sir, and so if that's the condition, it would be my intention to ask this committee to subpoena them. And I would, this is a situation where there's a lot of public activity. I ask you to submit the names of the people who've received the bonuses, noting that they paid them back or not, and I won't accept them under confidentiality personally. In fact, you submitted some confidential information, and I frankly threw it away after reading it because I was afraid I would inadvertently breach the confidentiality. But I do ask that you submit those names without restriction, and if you feel unable to do that, then I will ask the committee to subpoena them.
Congressman, if you'll let me explain, I very much want to comply with your request. I would hope it doesn't take a subpoena. If it does, then we will obviously comply with the law. I'm just really concerned about the safety of our people. So let me just read two things to you. All the executives and their families should be executed with piano wire around their necks. My greatest hope. If the government can't do this properly, we the people will take it in our own hands and see that justice is done. I'm looking for all the CEOs' names, kids, where they live, etc. You have a legitimate request.
Well,
I want to protect the well-being of our employees.
Could I get an additional minute by unanimous consent, because this is a subject to be addressed? I understand that. Many of us get these kinds of threats. Clearly, those threats are despicable. People who engage in this kind of threat, and I would say to my colleagues, the rhetoric can get overheated, so we ought to be very careful. That's why I want to be very clear, Mr. Liddy, that I disagree with the way you've handled this, but I understand that you inherited it. I disagree with the people who wrote those contracts, but it did not appear to me to be criminal. I will be willing to be guided to some extent by what the security officials may say, but this is an important public subject, and my guess is that there are probably threats aimed without too much specificity about people who work there. So I am going to keep that request on the table. I will consult with the law enforcement people, including the federal law enforcement people, and if they tell us they think there is a serious threat, we will have to take that into consideration. But I do want to keep that request on the table, and it is subject to our being persuaded. If I ask for a subpoena, there'd be a committee markup. It's not a unilateral decision, and yes, it's legitimate to take into account. I have to say that is, if we give in to these kind of threats, we would never get information made public about a lot of things, and I would certainly ask that the state and local and federal law enforcement officials give full cooperation, and I would urge that any threat that anybody even comes close to carrying out, or even threats which themselves can violate the law, be prosecuted. But at this point, I am not persuaded, but it is I will ask before we act that we get information from the security people, and that'll be before the committee when we vote. Thank you, Mr. Chairman.